Hey everyone, welcome to the weekend edition of The Bullet for October 29th, 2022. I'm Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. I've got a full crew here with me today. Up first, to my right, Rob Morse. Rob is Self-Defense Gun Stories. He also helps me with Polite Society podcasts. On Monday night, he has the Slow Facts blog, which all of you should be reading. And his stuff is picked up at like every place that does Second Amendment news. They carry Rob's stuff, or they should be. So that's Rob. Up next, Alex Ooley, and I have an issue talking today. My mouth is not as fast as my brain. Alex is an attorney and firearms trainer. Alex, you have the Ooley Law Offices, and it's O2 Gun Group, if I'm remembering right?
That's correct.
Okay. And then also with us today is that rascally rabbit. Mike Piwowarski is, of course, Arms Room Radio and The Rundown. And today, guys, is a week in review show. And as we get started, I want to remind everybody, if you're catching us live anywhere, it doesn't matter where you're catching us, you can always go to Twitter. Now that Twitter is free, you can go to Twitter, tweet with the hashtag #TheBullet. We'll get your comments right away. We'll put them on the air. If you're watching on the Polite Society podcast, Facebook or YouTube feed, you can comment on the live video there and we'll get those comments. But if you're watching anywhere else, go to Twitter, tweet with the hashtag #TheBullet. Stories I want to get to, and we're going to be leaning on Alex pretty heavy the first two stories. Alex, you and I talked last time we had a Legal Friday. There was an individual from Mississippi suing the state of Alabama because he couldn't carry in Alabama state parks without the written permission of that park's supervisor or superintendent. And it looks, at a story that broke today, like Alabama folded starting January 1st. This story I got off WRBL.com. Starting January 1st, Alabama state parks are going to follow Alabama's law that goes into effect that day. And if you're not a prohibited person, you get to carry in Alabama state parks. My opinion is this is just Alabama seeing the cards in the wall, and they just folded. What do you think, man?
Yeah, I agree. I think that Alabama likely realized that if they kept this law in effect, that it would be challenged and ultimately fail. And it had been challenged, but the litigation hadn't gone through to fruition or completion. And my understanding is that the policy before was that only law enforcement officials could carry firearms into the parks unless the manager of the particular park said that you could, that you had permission. And I think that this sort of law or policy would clearly fail in light of the Bruin decision because it wouldn't be consistent with the text, the history, or the tradition of the Second Amendment. So I think Alabama saw the writing on the wall and went ahead and preempted further litigation by making this go into effect at the beginning of the year.
Sure. Rob or Mike, either one of you want to chime in here?
Oh, Go ahead, Rob. This is great news, but Alex, did we miss an opportunity because this didn't go through the court system? It hasn't been written into precedent. You know, I've often thought that a really brave pro-gun legislator would almost write a bad piece of law, beg for it to be challenged, put up a fake defense, and let that decision cascade up into higher and higher courts by how he appealed. So do we have to then sue every park district in all 50 states to get them to adopt this?
Yeah, I take your point, and obviously we have on our side of the argument limited resources and don't want to have to fight this issue in every state. So I think that it's a good thing that Alabama saw the writing on the wall and decided to remove their restriction on law-abiding citizens carrying firearms in their parks. Nevertheless, I think this issue will have to be addressed in other states. And you're right. I think if this challenge had gone to fruition, we would have had some good precedent come from it. But I think ultimately a lower Alabama court would have been the one deciding in favor of law-abiding citizens exercising their constitutional rights. So I think it would have been precedent, but at a relatively low level in the Alabama court system. So it would not have had a widespread effect, I don't believe.
So let me be a smart aleck here. Lower Alabama. That's an L.A. court. We're going to get a victory in L.A. court?
Yes, exactly. Yes.
I'm curious why was this even an issue? This is the state of Alabama. Their new law takes effect to January 1st with their constitutional carry, if I'm correct, right?
Yep.
And this is the State Division of Parks. It's not the federal division. This is not Army Corps of Engineers. This is the State Division of Parks and Recreation, or whatever they call it. Why was this an issue? That the State Department of Parks takes their orders from the state of Alabama. The governor, this should have been a phone call. What are you doing down there, knucklehead? It's the law, January 1st. Just quit trying to make a job. I'm not sure why this got to be the issue.
Well, hold on to that thought, because we've got a Georgia story coming up later in the show. The next one, and I want to lean on Alex for this story too. This one comes off the Reload, Stephen Gakowski. California's attempt to stop people from building their own firearms can move forward. That's a decision by a federal district judge, George H. Wu, delivered late last week. Wu determined the Second Amendment's text does not cover the building of firearms, ruling against gun mill maker Defense Distributed in its challenge of AB 1621. The judge ruled California's law banning the possession of unserialized firearms as well as parts or tools used to make them does not run afoul of gun rights protections under the Supreme Court's Bruin decision. Basically, and I'm going to summarize a lot here. Basically, what this judge is saying is that Bruin affects your right to keep and bear, but not to manufacture. Yeah.
Right. I think. Yeah, I think that's essentially the argument that he's making, in that he says if you look to the Bruin decision, the threshold question is, does the Second Amendment's plain text cover the issue here? And he's saying that the issue here is the manufacture of firearms, not the keeping and bearing of firearms, as you said, Paul. But I think what the Bruin decision says is does the regulation or law burden the Second Amendment right? And I think it clearly does. If you can't manufacture firearms, that limits the ability of individual citizens to exercise their right to keep and to bear arms. And so then the question is, does it burden it? And if it does, then is it consistent with the text, history, and tradition of the Second Amendment?
Well, and go ahead. I'm sorry.
No. Go ahead, Paul.
Going back to history, in 1791, there were not very many machine manufactured firearms. They were largely individually hand built. So, as a matter of fact, I watched a documentary on YouTube TV the other day that Eli Whitney, the inventor of the cotton gin, lost his shirt on the cotton gin, but was one of the, and this is after the Revolutionary War, was one of the people that was key in bringing large-scale manufacturing to firearms. And that, again, is post-1791. So if at 1791 they were individually making firearms, you got to think the history lies on individuals making firearms.
Yeah, I would think so. I'm not a historian by any measure, But I think you're correct in that the history would support the individual manufacture of firearms and came before the mass manufacture of and commercial manufacture of firearms.
This judge is. I'm trying to think of the nice word for idiot. I'll just go with idiot. I guess manufacture is something that it's just we don't have to worry about manufacturing firearms. In order to have a firearm, one must manufacture a firearm. We can't just miracle the firearm as much as we'd all like to. It has to be manufactured at some point. You have been allowed to manufacture a firearm legally in this country since 1791, right? Before that, you just could do it. So 1791, there's your historical text right there. It's always been done. The non-serial number issue. Let's do the math. No serial number required until 1968, right? And that was only if being sold commercially or being imported. So you could still build in both states a firearm without having to put a serial number on it, unless you plan on selling it import or export. So this judge ignored Bruin and everything but writing the Bruin name down. He did nothing to follow or comply with it. It's one of those just ripe to be thrown out. Listen, we just had another federal case last week, right? We're at the federal appellate level. No serial numbers required on firearms, and that was somebody that had removed a serial number from firearm, didn't just manufacture one without. This case is just waiting to be tossed at the next level.
Guys, if you shoot very much, you clean your guns. In fact, you take them completely apart, you reassemble them. If you shoot very much, pretty soon, it's hard to tell when the old gun started and the new gun you're shooting now began. So when did we build a gun? California was requiring the serialization of all gun parts, not just the receiver, not just the frame. Oh, that barrel, that magazine. They wanted everything serialized. And as Mike points out, other states have ruled that requiring firearms to be serialized at all is an infringement. So this is going to be appealed. It's going to be amazing to watch this torn apart and picked apart by better judges than this one.
Yeah, I'm agreeing with you, Rob. And for some reason, we were getting comments coming in on the Facebook side. My software isn't picking them up, so I'm just going to read them. I can't put them on the screen. Gerald D's on Facebook says, wouldn't that say gun manufacturers can't be shut down? Yeah, but they're taxed into oblivion in California. And Michael says they want to make all gun parts go through FFL to make them unaffordable. Michael just found the sweet spot right there. I believe that is exactly. You want a spring for your Glock magazine? Guess what? It's going to be at $50 for that one mag spring.
Well, and rather than have it sent to your home, which is what we do now, you have to go to your firearms dealer. For all I know, California will then require that you run a background check for a mag spring. Yeah. Mm-hmm. Yeah.
It's going to be fun to watch all of California's firearms laws fall by the wayside. And it's going to be a fight. They're going to go kicking and screaming, and they're going to get every ounce out of it that they can and throw injunctions all over the place. But with Bruin, they're going to lose them one by one. And I'm sorry, this you can't, or manufacturing doesn't infringe on possessing is as dumb as the argument of, well, if we can't ban guns, we'll ban ammo. And the court said, listen, you can't have one without the other. Well, guess what? You can't have the firearm unless somebody manufactures it. It's going to fall fast and hard.
Yep.
Alex, okay, buried in this too is a question for Alex. Now with the Bruin decision, as these many state laws are challenged, are they now recognized as a violation of a civil rights law, the right to keep and bear arms, so that court costs and attorney's fees would routinely be recompensed?
Yeah, so if you file a lawsuit under what's typically called a Section 1983 claim, the prevailing party can be compensated or is entitled to attorney fees for the expense of their litigation. You could also be entitled to fees or damages to the extent of the harm that you've suffered. So I think that the problem is that you typically have to prove an intentional violation of a constitutional right, and there normally has to be some precedent in place before there can be some intentional violation of the right. So I think if there's precedent, there's legal authority that clearly shows that these laws are in violation of a civil right, then these sorts of lawsuits could be brought against the governors of each state. And I think that Bruin, in our eyes, clearly shows that these are in violation, but I don't think that those sorts of civil rights claims would prevail until some of these more particularized lawsuits are fleshed out. And then if they're still violated after these issues are fleshed out, then I think there may be some civil rights claims to be brought.
Well, we have seen some attorneys' fees awarded. What I think is such a tell, a lot of the laws we're seeing now challenged weren't in place until Bruin passed. Oh, you have the right to bear arms. Oh, not so fast there. That'll be interesting.
Well, and Rob, I've seen, I talked to Alan when I was working from Washington for that week, working from the home offices, and the checks that SAF got from the city of Chicago with that beautiful Rahm Emanuel signature on them did not cover the costs of that lawsuit. It covered some of the attorney's fees. The SAF did not get all of the costs for that lawsuit back. A share of it, yes, but it still didn't get, SAF was not reimbursed for everything. And that it's good that they got some of it back, but I'm glad that Chicago had to pay, and I hope New York, New Jersey, Hawaii, California have to pay a lot, but I don't see them having ever to reimburse all of it. I don't think that's. I don't think that's
a great point, Paul. Because once the underlying case is resolved and the plaintiff presumably wins, then there's further litigation about what reasonable attorney fees are owed by the opposite party, and it's generally not going to be the full cost of bringing the litigation. So that's definitely a good point.
Get some more comments in here. Krabby Turtle, by the way, great screen name. But Krabby Turtle says, I'm thankful Maryland's governor followed suit early as soon as New York Rifle and Pistol Association case came out. D.C. too with Heller. There are some jurisdictions that are falling in line. Maryland, kind of D.C., but we've got a story on that one later in the show too.
And I'd like to go back to a point that Mike brought up. Mike, you mentioned that serialization wasn't required until 1968, and I think that's a great point to bring up because there is still this ongoing argument about which period of history do we look to when we're evaluating a law or restriction under the text, history, and tradition analysis. And I think the answer is, 1791, but I think it's clearly not 1968. At most, I think the best argument that's been presented by the gun control advocates is the Reconstruction era when the 14th Amendment was adopted. I don't think that's the correct era of history to look to either, but I think that's their only plausible argument to make. And I think it's clearly not 1968.
Well, and Alex, would they include all the racist Jim Crow laws in there too?
Well, I think that's why they don't say that's why, but that's why they're looking to that period of history, because that's when gun control really began, was when We had all these newly freed slaves, and there were a contingent of primarily the Democrats who did not want newly freed slaves to have guns. So that's one of the first examples in history of gun control, and that's why you have to look to that period of history to find the first gun control examples or analogs, as we know from Bruin.
Who was it that did that? Was it New York after Bruin came out and they were arguing? The state came out and said we can restrict firearms ownership because that's what was done basically since the Reconstruction era. So
right,
their reason was, listen, we had unconstitutional laws back then, so that makes it okay to reenact them. It's just, and I think we made the analysis. Well, I mean, it's like citing, Brown versus the Board of Education to go ahead and segregate again. No, guys, we're past that now. You can't cite unconstitutional laws as your reason to enact a new law.
Michael, I'll disagree with you. And Alex, you're a lawyer. Lawyers can argue anything they want.
Sure they can. Yeah.
Are we going to put up with it?
Yeah, right.
Well,
I'm not going to argue with you on that one, Rob.
It was successfully argued at one point before the Supreme Court that a black man was worth 3/5 of a white man. So you just
that
saying,
was in terms of the census. So let's be careful, right? Okay.
I'm just saying the Supreme Court has and can make mistakes. I want to skip down a little bit in show notes, and I want to talk about another lawsuit because I want to keep Alex active here early in the show. A story from the Washington Post. I'm going to just read a little bit of this story to begin with. When D.C. security guard Sanu Millard turned 21, he decided he wanted a concealed carry license. He carries guns at work in the district, Maryland, and Virginia. He'd been trained to use guns safely as a teenager and had legally registered 2 weapons. He had no criminal record, and as the Supreme Court interprets the Second Amendment, carrying a gun is his right as an American citizen. But when Millard tried to get a concealed carry license from D.C. police in 2019, his request was denied, even though he had never been arrested. Police said his involvement in a domestic violence incident, an incident in which he says he and his mother were victims, disqualified him. Now 24, Millard has sued the district, alleging it discriminates against some people by denying them concealed carry licenses, and many of these people are black men. The lawsuit said the D.C. police unreasonably refused licenses to those with minor criminal convictions and arrests with no convictions, sometimes unfairly using their involvement with violent incidents against them. There was another case in there where somebody was shot at, and because the crime involved a gun, and even though they were the victim, they were denied a carry permit. I do not know if there's racism in the D.C. Police Department. I would rather doubt it, but I certainly hope that these 3 plaintiffs are successful in their suit. Have you been able to look at this one at all, Alex?
I read the article. I haven't read the suit in particular or the complaint. But what's interesting to me is that this is just another example of the anti-gunners trying to set up some criteria to disqualify people from exercising their constitutional rights and casting that net as wide as possible. I mean, if he was the victim in these domestic violence incidents and they still disqualify him, I mean, that's clearly just an arbitrary method to disqualify people who would otherwise be able to lawfully carry a firearm. And this is just an example, like I said, of casting the net as widely as they can. I think, let's see, the suit apparently says, it quotes part of it here in the article, that the burden of the districts and the police policies falls more heavily on African Americans than any other segment of applicants. And that may, in fact, be true, but just because African American men may be more affected doesn't mean that there's some bias built into the system at the beginning. So I don't know whether or not they'll have any legs to carry them forward in the lawsuit on those grounds. But I think these issues about arrests with no convictions and being involved in domestic violence incidents, again, with no charges, no convictions, I think those are clearly beyond the bounds of appropriate reasons to disqualify someone.
Rob, Mike, you guys want to chime in?
Go ahead, Rob.
You brought up racism. I don't think we need to go there. We have plenty of very telling evidence. It's elitism. Elitism explains why Democrat politicians in D.C. who are representing their big money donors, those are the people who want ordinary citizens disarmed.
Well, I think
now there's something that's interesting. At some point, judges have ruled, this isn't a case for judges when you voters can solve this at the ballot box. At some point, I have to agree with them.
I think a little bit of this may be the elite in the police, the upper echelon of the police department, commanders, chief of police, whatever. We've got ours. Go pound
why should
sand.
We share?
Yeah.
The that upper echelon of police, law enforcement, whatever it is, that's the politician level, and that's all it is. They're there, just bending over backwards for the mayor and the council because they want to keep their job as well. This is. Besides, it's DC, right? Because of DC, I mean, that's why we have Heller to begin with. We know they're going to continue to fight every step of the way, much like New York and California, New Jersey, and everywhere else. But this is to consider the victim of a domestic violence ineligible to get a concealed weapons permit. One of the things I'd like to see now that we have brewing, now that things are going forward. I worked in the clearance business for a lot, getting stuff taken care of, and the burden on you're forgetting approved that it should be, the burden should be on the state to disprove your eligibility. It shouldn't be on the applicant to prove their eligibility, if that makes sense. This is something granted to you by the Constitution. You're not applying for a driver's license. It's not a privilege. It shouldn't go the other way. The burden should be on the state here to disprove your eligibility. This whole, he was part of a domestic violence. We want to see the rest of the report. Well, you're the government. You go pull the report and find out that I'm the victim, not the suspect. And I was arrested, yes, but like Alex said, never charged. You're right. Well, we need to see your clearance paperwork. You're the government. Walk down the hall and get it. Not my job to do your job for you. The other cautionary tale I'd put out there, because this story kind of brings it back to the surface for me. If you have a security guard license in a state and you go get a concealed weapons permit or your regular carry permit, don't mix the two unless the state says you can. In most places, the personal carrying of a firearm does not mean you get to carry that firearm for work unless you have a work permit to carry that. So just for anybody listening, don't get that confused. Check your state laws and don't get in trouble for something that you don't need to get in trouble for.
And check your state laws. Pete over on websites.
Mike, you bring up something. There were people, and I recall it, out of New Jersey. This guy was a security guard, and he gets busted for having his work gun in his glove compartment because I think he had to make a trip home. He goes, I can't carry. Where can I put it? Puts it in the glove compartment and gets busted.
I remember that.
Yeah, and I think that will be. They'll find out that it was stored correctly, if I recall. Remember, because it was in the glove box. He did not have, constructive possession or immediate access to it. So it's clearly one of those cases of it's New Jersey. We don't care what the law is. You got a gun, you're going to jail.
Yeah.
Right.
Pete over at Gun Website says, I know a guy with a DC concealed carry permit. I know one person I've met one person. That's Emily Miller. Emily Gets Her Gun. But they're not as rare as New Jersey permits, but they're not common.
Right.
And Mike, I was going to mention to your point about the burden should be on the government to disprove the eligibility of somebody to exercise a right that they already have. And this is an argument that comes up a lot in the constitutional carry debate or the permitless carry debate, that states should be able to require people to obtain a license to carry a firearm. But that's what you're doing when you're obtaining a license, is you're going to the government, you're paying to get back a right that you already have and proving your eligibility. Well, that doesn't sound like a right at all. That sounds like a privilege, like you said. It's a privilege if you have to ask permission to exercise it. Yep. And that's exactly what's going on.
All right, let me get this one in, because I missed this when it scrolled by, because we're getting so many comments. I missed this one when we got it first. Krabby Turtle says, I just received my DC carry permit yesterday. Congratulations, and you should be a celebrity now, man. Wow, that's cool.
I swear it's related, I think, a little. Because of the huge variability in how districts or jurisdictions are processing applications in New Jersey. Some places there, it is still tooth and claw and, look, we want your dead mother's signature on the application. And other places are, oh, you're from out of state? You want a permit? Sure, we'll issue out-of-state permits. So the lawyers aren't done with this yet.
Looked over at the Facebook side, and they're still not showing up for some reason. They're sporadically. One is, others aren't. Michael over on the Facebook side says, supposedly DC shall issue and does issue non-resident concealed carry permits.
Yeah, but you've got to go train by their DC approved. Yeah,
right. And you have to apply in person. Yeah.
Yeah, it's hard to get one from here.
Yeah. Just mess. I'm waiting for the 14th Amendment to apply to concealed carry permits. When my South Dakota enhanced permit allows me to carry in D.C., then I will make a trip to D.C. What do we want to talk about next, guys?
New Jersey?
Yeah, let's.
Or did you want to back up and get Oregon?
Let's. Well, they're neither one are good stories. They're neither one are good news.
Right, but both are important.
Yeah, let's talk about New Jersey. They have been rushing a New York style bill up through the legislature, and I do mean rushing. It was fast tracked until Thursday, when apparently they talked to an attorney. And Alex, did you get a call from New Jersey on Thursday?
I didn't, but maybe they should have. I would have told them just to scrap it all. So
this from the New Jersey Monitor: a fast-track bill to limit concealed carry in New Jersey hit a snag Thursday when Assembly leaders yanked it from a scheduled vote, conceding its broad restrictions could fold under constitutional scrutiny. The canceled vote came the same day a Senate panel approved the bill along party lines, and with about 15 amendments that appeared to be aimed at appeasing critics who have vowed to fight any new law in court. The bill, introduced 2 weeks ago, has already been approved along party lines by 3 Assembly committees. Skipping down in the story, Assemblyman Louis Greenwald, one of the bill's sponsors and the majority leader in the assembly, said legislators plan to revise language in the bill to ensure it's directly in line with our legislative intent. That may help constitutional arguments at the end of the day, he said. There's a focus on making sure it's not too broad, too vague, and that it withstands a challenge. He said lawmakers still aim to pass the bill by the end of November. So they're just going to have to wait a little longer before facing the SAF in court, I guess.
The law was so... Go, Mike.
Okay. Since the Democrats all got together and pushed this through very quickly, would that be rushing collusion?
Wow.
The excellence.
That's what you call a stretch.
Network. That's what we do. Well, to say that they forced this through without due consideration is an immense understatement. They so broadly defined weapons that they inadvertently said you couldn't have a knife in a commercial kitchen. You couldn't have steak knives in steakhouses. You couldn't have scalpels in hospitals. Somebody pointed this out to them and they went, well, but that's not what we meant. And the guy goes, I don't care what you meant. I'm just reading the law the way you wrote it. The world is full of dangerous, dangerous tools, which we use successfully every darn day. They wanted to make it a law for you to have a weapon.
Mike, there are professional baseball teams that play in New Jersey, right? Don't the Giants play in New Jersey?
No, you're thinking of the football teams, because remember we talked about this, Paul. Connecticut was created for tax freedoms. Massachusetts was created for tax freedoms. New York for religious freedoms, and New Jersey to host New York football teams.
Okay. All right. Well, regardless, they cannot have. They're going to have to ban baseball from New Jersey because baseball bats. I'm fairly certain baseball bats kill more than rifles do.
Yeah, it kill a lot of careers, that's for sure. There are minor league teams there, and so professional baseball. There is professional baseball, just not Major League Baseball. So yeah, sorry.
All right.
One of the good things I wanted to point out with the resistance to this bill, apparently some people complained about a provision that would allow the 565 municipalities to define their own sensitive places where guns could be banned. There was enough resistance to the bill in that particular provision that apparently that has been removed. I couldn't imagine in a state as small as New Jersey with 565 municipalities that might have different rules about sensitive places. That would be basically impossible to comply with or to know what constitutes a sensitive place in any particular municipality. So at least that provision was removed. But I don't anticipate that the final bill that gets passed will be a good one nevertheless. So I think SAF will continue to have lots of work to do on this one.
Anthony Calandro covers New Jersey firearms law pretty well every week. I suggest you listen to the Gun for Hire podcast. Paul, I don't think I'm speaking out of school to say that.
No.
And they routinely have, Jensen Schmutter and the guy, ANGRPC, I forgot his name, the other lawyer.
Scott Bach?
Thank you, Scott Bach. And they are trying to talk to legislators going, we'll sue you about a minute after this, after the ink dries. Maybe they listened. Maybe their own lawyers finally said, you can, but you're going to owe attorney's fees because this is so egregious. Alec, what do you think?
They don't care. It's not their money they're going to be paying with. You're not going to go after them individually. They're just going to pull it out of the coffers and maybe tax you a little bit more, raise your millage rate next year, and pay it back that way. As long as they can continue to stifle our efforts to restore that Second Amendment freedoms, they will.
Yeah, as long as there's no skin in the game for them, like you said, Mike, it's
Right.
not their money. They don't feel the heat of going forward with these sorts of things.
Yeah, let's. I want to. I want to jump coasts. I want to talk Oregon for a few minutes. There was a, and I'm trying. KGW.com had a story earlier this week pushing for Measure 114 in Oregon, and what the reason they're pushing for it, it's going to reduce firearm suicides in Oregon. The reason it's going to do that is because it's got a built-in waiting period. Well, the waiting period they're talking about is not part of the bill itself. The waiting period they're talking about is you got to go through a background check, then you got to go through training. Oh, and by the way, that training includes live fire training, which means you have to have a firearm to get a permit to purchase a firearm. And regardless, they're saying that there will be fewer firearms deaths in Oregon because there's going to be a delay in getting your firearm, which will cause suicides to go down. I don't have numbers in front of me, but I find that highly specious. I don't. If somebody's going to have made the decision they're going to commit suicide, they're going to commit suicide. Whether it's through firearm, through knife, through semi-truck, through death by cop, it's going to happen.
Paul, I want to read the ugly details, if you don't mind.
Do it.
This ballot measure would require a permit before you're allowed to purchase a firearm. The permit is good for 5 years, and an applicant would need to complete a firearm safety course, pay a fee, provide personal information, provide fingerprints and a passport photo, and pass a criminal background check before you can buy a gun. So it outlaws person-to-person transfer. What we need Alec to do, I'm throwing you on the spot here, and I know it's not fair. Often these bills conflate possession with ownership. So if you have a gun in your hand, are you the gun's owner, or did your buddy say, hey, you want to try and shoot this? Some states deliberately say before you can possess a firearm, you have to go through all these hoops for each firearm you own, which means literally if a guy wants to say, hey, you want to sell me that gun, can I shoot it first? And we're standing at the range. Supposedly we need to go through a transfer process so we can hold it in the bay and shoot it. Gets ridiculous really quickly.
Well, and the other thing that this Oregon proposed legislation would do, that the voters are going to be voting on in 10 days, is there is no limit, there is no time limit now in Oregon for a background check to complete. Everywhere else in the country, if it's not back in 5 business days, 1 week, it's up to the individual store whether they proceed with the sale or not. In Oregon, that goes away.
Yeah. It's the same scam New York tried to pull. Remember, the background check when you get it from NICS is only valid for 30 days to begin with. So this is their excuse to, we did the background check, but we didn't get around to the paperwork until the 32nd day. Now you get to come back in and do it all over again and just keep them going every 30 days in perpetuity. It's just more scams for them to keep you from getting the firearm. To touch back on the suicide thing for a moment, and that's something, listen, we've all worked at it at a certain level. These people are these politicians there. I'm trying to think of the polite word. Politicians there in Oregon, they actually believe that if they put a waiting period in, that the individual who wants to commit suicide is not going to seek out the firearm if they've decided that's how it is. This is as stupid as a gun-free zone sign, because you're saying, listen, we're gonna make it a crime if you violate this. So if you get a gun and kill yourself, we're then going to charge you with getting the gun illegally. It's absolutely moronic logic the way they come about.
Mike, just because it's such odd bedfellows, some of those opposing this ballot measure in Portland are the Socialist Rifle Association. I didn't even know there was such a thing. To quote them, law enforcement should not be responsible for deciding who is allowed to be armed, especially when law enforcement has a long and recent history of oppressing marginalized groups, close quote.
Welcome to the club, folks.
The other point I'd like to make about this story, too, is remember, the question is, does the particular law burden the Second Amendment right to keep and bear arms?
Right.
And I think clearly it does. And so does it survive the test set out in Bruin? And that is, does it meet the text, history, and tradition analysis? And I don't think that it does. But what's happening here is the state of Oregon is trying to engage in this interest balancing that the court in Bruin clearly said that states should not engage in. They're trying to say that there's this public policy initiative that we want to achieve by reducing suicide, and we think it's okay to burden the Second Amendment right in these ways because of public safety. And that's exactly the sort of interest balancing that the Supreme Court in Bruin said that governments should not be engaging in when deciding whether or not to infringe the Second Amendment.
And all states are doing that, all left states, right? All blue states. We just talked about New Jersey. Now we have Oregon doing it. And I know we've talked about this before. Until there's a consequence for the politicians that continue to put forth unconstitutional laws, or they have to burden the cost themselves, they're going to continue to do it. I think that we should apply to politicians, to judges as well, the same qualified immunity that law enforcement has to wear as their protection, instead of complete immunity. If you knowingly violate the law or violate someone's rights, then you could be held civilly responsible. I think that's the way to get these politicians to stop, coming up with these ridiculous. Again, they know unconstitutional. They don't have to burden it legally or civilly or financially. Until that happens, these are going to continue every day.
Yep.
Paul, can we jump down to that Lott article?
Yes, but give me 1 second here. I want to get.
Okay.
We've got DJ Play Nice up on screen. American Foundation for Suicide Prevention, ASFP.org, and I want to get one more up because I'd not known about this one before. He says DJ also put dial 988. I knew about that. 1-800-243-TALK. Don't want to talk? Then you can text TALK to 741-741. Thank you, DJ Play Nice.
Yeah.
Rob, go ahead and let's go into that next one.
Okay. This is from a recent report by, I get to call him an associate, don't I? Because, well, anyway, Dr. John Lott. He's at the Crime Prevention Research Center. He went back and looked at 7 years of data between 2014 and 2021. Citizens stopped 104 out of 204 potential or actual mass shootings when we could identify that the guns were allowed in that area. So let me unpack that a little bit. To say that there was a mass murder in a gun-free zone doesn't really tell us anything about whether armed citizens are an effective deterrent, because the law disarmed them there. So Lott goes back and sorts out where we were able to carry, where we weren't, where we were attacked. The numbers that fall out of it are amazing. 51% of attacks were stopped by people legally carrying concealed handguns in places they're legally allowed to be. If someone said that Alex, Mike, Paul were able to stop mass murder just by carrying to the mall, holy cow, that puts an entirely new complexion on gun-free zones. And again, the most recent data is the most accurate. In 2021, 58% of the attacks were stopped in areas where we were allowed to carry. Dr. Lott started digging through this data after reviewing an FBI report, and the report, which said that only 4% of attacks were stopped by armed citizens, Lott said, no, that's 34% because you missed so many examples and you didn't sort in this factor of gun-free zones. Well, the report shows that gun-free zones are horrible ideas. My complaint is that secret is safe because the mass media would never write up and carry that report.
Yeah, I've seen it. I've seen coverage of it, but only in our circle, the Second Amendment media. I've not seen it anywhere. Even Fox News hasn't covered it, and he's a contributor for Fox News.
So, Mike, Alec, you guys have shows. I think that's a relevant topic.
John Lott was on the Four Boxes Diner with Mark Smith recently about this issue, and he made a few points in that interview. These numbers that John Lott came up with were using, I think this is important, using the FBI's own definitions. So even with the FBI's definitions, they severely undercounted the number of times that armed citizens stopped potential mass shootings. And he also mentioned that he only expended a couple $1,000s looking into these numbers and getting the data to show that the FBI was wrong in undercounting. And he made the point that the FBI, there's no telling how much they spent, probably millions of dollars compiling these numbers, and just a few $1,000s and a brief investigation into this shows that their numbers are clearly wrong. Mm-hmm. So they're systematically undercounting these numbers. And obviously we can speculate why they might be doing that. But I think if you haven't heard that interview, it's worthwhile listening to, because it sort of supplements this article from his website, crimeresearch.org.
Another curiosity, and Lott admits this, he goes, even though I say there were a lot of self-defense events, he had found 21 places where armed defenders stopped the attacker before the attacker fired his first shot. So it's not the example, one of them that he cited, this guy all kitted up walks into a mall in New Mexico, and an ordinary guy taking his stuff out of the mall goes, "This doesn't look right. What are you doing?" And he holds the guy at gunpoint, says, "Would you put that rifle at least barrel down?" And a mall cop shows up, not a mall cop, a police officer in the mall, takes possession of the guy. The guy who's kitted up reaches for the officer's gun and then gets shot. Who stopped the attack? Was it really an attack? The guy was clearly there to do crazy.
Yes.
So Lott admits that some of the numbers are hard to define.
Yes.
He mentions the story of Elijah Dickin in Indiana. It was at a mall here in Indiana. There was a shooter who came out of the bathroom, and in fact, I believe the first victim was an armed citizen who was standing near the entrance to the bathroom and didn't have time to use his firearm. But Elijah Dickin did, and hit, I believe it was 8 out of 10 shots with his handgun from 40 yards. So it's just an example of, an armed citizen who has good marksmanship and courage can save who knows how many lives. It could have been a lot more lives lost that day. But the media, the national media especially, ignores these sorts of events because they say, well, that happens so rarely that we're not even going to pay any attention to it because it doesn't fit their narrative.
Right.
But this is the sort of behavior we want to encourage and cover. We want people to protect themselves and others, but instead we give all the attention to the killers themselves. So I think this is somebody who deserves more attention. It's an example that it's not rare, but is an example of somebody who showed incredible bravery and marksmanship.
Fair warning, we're going to go over time. We do not have time. I want to cover one more story. I want to get to some comments. We're not going to get that all done in 5 minutes, which is what we have left. So we're going to go over. But, Rob and everybody, I want to talk about Zoo Atlanta here real quick. This is a victory, but it's a victory that it's a sideways victory. I'm going to read from the story here. Zoo Atlanta has dropped its new weapons ban following a challenge by a gun rights activist. Let's be clear, this is talking about the Atlanta Zoo, not the zoo that is the city of Atlanta. The gun ban at the Atlanta Zoo was repealed on October 28th, the day after the zoo's operating agreement appears to legally prevent it from banning guns under the Supreme Court of Georgia precedent, but there still may be legal questions. The zoo's gun policy has reverted to the one that existed before September 1st, which allows weapons permitted by law. That policy was created when Georgia required permits to carry a gun, which is no longer necessary after a state law change earlier this year. The zoo says it will still only allow weapons with a legal permit. Also implied, it considered challenging state law, but instead is urging government officials to rethink gun policy. Zoo Atlanta continues to believe that its decision to prohibit carrying of guns onto Zoo Atlanta grounds is legally supportable and in the best interests of safety, said the zoo in a written statement to the paper. At this time, however, Zoo Atlanta is choosing not to undergo the major distraction and expense of litigation, but will instead give public officials an opportunity to consider and address this issue. In the meantime, and effective immediately, Zoo Atlanta's weapons policy will revert to its original form, which allows guests to carry weapons as permitted by law. Zoo Atlanta recognizes and maintains the right to pursue further analysis of this policy. Now, the story goes on to say, however, there still may be legal confusion because the original policy basis in permitted weapons, Zoo spokesman Rachel Davis said, our statement permitted by law means that guests may carry only with a legal permit, but licenses are no longer required to carry guns after this year's controversial concealed carry legislation. I think on the zoo's part, this is, please don't sue us, but please don't carry here, I think is what's going on there.
Alec, will you talk about the distinction? Oh, go ahead. Sorry.
To say, sorry, Zoo Atlanta, you know, whatever your reasoning is, it's your law. Just like the first story with Alabama, you got a subsidiary government entity that thinks that they don't have to obey by the new state law. Yeah, guess what? You're a public zoo. You take public funds, and the public has the right to carry in there if that's what the law is. And Georgia is, remember, it's an open carry state also. In fact, Georgia's the place I think I see people open carry the most with firearms, and it's it. You know, listen, nobody's coming in there hunting. Nobody's coming in there scaring little kids. You know, they routinely carry their firearms in and around Atlanta. I do it when I go there. It's no big deal there. It's one of those states that's been a proud open carry state for a very long time. And well, it's always been one, but they've been doing it for a very long time without objection. It's just another sub-government entity that doesn't like it, and we're going to think about this new controversial law. That's what we're going to ask the politicians to do. Okay, great. Move on. Yeah. Go back to taking care of the animals.
Alex, would you make the distinction between a legally permitted firearm and an individual who has a permit or requires a permit to carry?
Yeah, I think that's. I think the zoo is just trying to hide behind a perceived ambiguity here, because I don't think that the firearms have permits. I mean, as you point out, Rob, it's the individual who has a permit, not the individual, or not the weapon itself or the firearm. So I think that the zoo is just basically hiding behind cowardice here and an ambiguity, because they're anti-gun, but they also don't want to be sued into oblivion and have to fight this out in court.
Well, I was thinking that, a hand grenade is a prohibited weapon. Yes, you could carry it. It's not allowed. Look, except when Mike plays on the weekend.
Well, I mean, if you have your class 3, handgun, your dangerous device, you could carry one because then it would be legally permitted, right? Because I have the permit for it.
Okay. Let's presuppose that there are some weapons that fall outside the range of weapons we're allowed to carry. Okay, now I'm carrying a legally permitted weapon. It doesn't necessarily mean that the individual needs a permit, and Georgia law says he doesn't.
Right, and I'm guessing it's stuff like, converted to machine gun class 3 stuff that's not done on paper. I mean, that's all I could stretch and think. Maybe that's what they were trying to say. I don't know.
Okay.
But.
Yeah.
And here the article toward the end. Well, it's actually not quite the end, but the Evans, the person who had the lawsuit, said that the zoo is unaware of their own incompetence, and I don't know that I'd give them that benefit of the doubt. I think that they're completely aware of what they're doing. He says, once again, they seem to be unconscious of their own incompetence, and I think that that's giving them too much of the benefit of the doubt.
Very, very well could be. Yeah. Let me go to some comments here because I just heard the tones in my ear from my timekeeping program I have that we're over time. But going back to a comment Mike made earlier, you get this one up on the screen. Mike had a great point there. Has the idea of making politicians responsible for unconstitutional laws that are designed to waste time or abuse the system ever been in a bill before? Gun websites, not to my knowledge. I do know the only example of anything close to that was in Florida. If a city was to go against preemption, state preemption, the city politicians could be held, could be forced out of office and possibly face criminal charges by the state. That's the closest I've ever seen.
And they're responsible for financing their own legal battles. They can't use the city, county government's gun or money. I'm sorry.
Yeah, very rarely do politicians face personal liability for violating someone's rights. Typically, it's going to be the taxpayers who are on the hook for their incompetence or their egregious acts toward civil liberties. And if the taxpayers don't hold them accountable by voting them out of office, then they can continue to violate civil rights on the taxpayers' dime.
Right, and Alex, that's the argument I hear all the time. Well, the repercussions for them is they could be voted out of office. Okay, great. So let's use the same standard that we would for citizens. Sir, you just broke the law, and if you do it again in the next 6 years, I'm going to send you home. That's no threat. That's the worst deterrence I've ever heard in my life. They need to feel the same pressures that, listen, just law enforcement. All right, the holders of law and order for the most part out there, they know they can't break the law or violate your constitutional rights. It's that easy. It's that easy. If we applied that to politicians, you'd never again hear, well, I know what the law is, but it's just the right thing to do, so I'm going to do it. And then we're all tied up in court for 3 years.
Right. No, I agree. I think that the threat of being voted out of office is not an effective deterrent. Unfortunately, for a bill to pass, you have to have a legislature that's willing to override an executive veto to pass something like this. Because
they could do it like they do raises. Listen, we're going to vote it in now, but it applies to the next guy that gets elected, not me.
Exactly.
All right, and going back to the Dr. John Lott interview that was mentioned on Four Boxes Diner, and Krabby Turtle and gun websites were nice enough to include a link in the YouTube comments. So if you're watching anywhere else and you want to see that interview, just look for those comments on YouTube, and you can pop over there and catch that catch that interview with Dr. Lott.
Good catch.
Let's do this, guys, because we're already almost 5 minutes over. Let's start wrapping this up. Rob, anything you want to plug on our way out the door, man?
I host the Self-Defense Gun Stories podcast. I'm a co-host on the SAF's Polite Society podcast. My blog is at slowfacts.wordpress.com. My writing's picked up at AmmoLand.
All right. Mike, your turn, man. What do you want to plug today?
Yeah, Arms Room Radio coming up today at 3 o'clock Eastern Time until 5 o'clock. Go to armsroomradio.com to listen live there, or you can see what stations we're on. Or maybe we're on a station near you. If we're not, let us know. We'll contact your local stations. And, of course, the rundown every day from 5 to 6 p.m. Me with my co-host, Mr. Craig DeLuz. And gentlemen, pleasure to be here. Thank you again for having me, Paul. Rob, good to see you, and good to see you, Alex.
Well, and if he's not on your local station, contact your local station. Say, there's this great program I'd love for you guys to carry. It's called Arms Room Radio. That works even better than Mike calling them.
Yeah. Sure, they don't.
Alex, anything you want to plug this week, man?
Yeah, so I'm an attorney and a firearms instructor. Ooleylaw.com is the legal website where I have a website and a blog. I occasionally blog about legal issues going on related to the Second Amendment and also other issues. I also have a firearms training business, o2gungroup.com. I, along with my family, have a firearms training business, and we actually have a 5-hour legal class that I teach along with my dad, who's also an attorney, about the lawful use of force in self-defense. So check that out if that's something that might be of interest to you. Rob, Paul, Mike, it's great to be with you all this week.
Thank you to all three of you. That's going to wrap up my week of broadcasting, and thank you all for watching. Thanks to everybody who's commented, contributed. And please do come join me next week, Monday through Friday, 5 p.m. Central Time. And again, of course, noon on Saturday for the weekend edition of The Bullet. Thanks again, everyone.